Hello, we are from Group 9. We will be presenting our drafted act, namely Women's Rights Act. The purpose of drafting this act is to protect women and their rights. In this presentation, we will explain which provisions represent which jurisprudence, the reason why we include such provisions, and how it's related to the Islamic jurisprudence and Western jurisprudence. Now, we will start with Section 3 of this act.
So Section 3 and 4 of the Act is about abortion. The main idea of Section 3 Clause A is that any intentional act that causes the abortion of a pregnant woman is illegal. This includes action by the pregnant woman herself. This provision was included in the Act to protect the sanctity of human life of both woman and her fetus. This is because, from the Western jurisprudence perspective, the general argument posed by the natural law regarding abortions from a moral point of view is inherently immoral. Natural law theory holds that one may never directly intend to kill an innocent human being under what circumstances and conditions. This includes for a woman to undergo an abortion procedure. Similarly, under Islamic jurisprudence, abortion is generally prohibited since it is tantamount to killing a human being that is not fully developed. Based on hadith Sunan Abu Dawud, the Prophet Muhammad SAW has condemned an offender to pay a ghurah and diyah for assaulting a pregnant woman and killing the mother as well as the baby. Ibn Taymiyyah also opined that in addition to the blood money, the person responsible for the abortion must atone the manslaughter by fasting for 2 consecutive months as provided by the Quran in Surah An-Nisa verse 92. Next is Section 3 Clause B, which outlines the illegality and penalties of performing abortion on women who are more than 18 weeks pregnant regardless of their consent. The relevance of 18 weeks was included to determine the stage of pregnancy. This provision is mainly based on Islamic jurisprudence, where Muslim scholars agree that life is breathed into the fetus 120 days after conception. This is based on Hadith Sahih al-Bukhari narrated by Abdullah bin Mas'ud, where Prophet Muhammad SAW said that verily the creation of any one of you takes place when he is assembled in his mother's womb. For 40 days, he is as a drop of fluid, then becomes a clot for a similar period. Thereafter, it is a lump looking like it has been chewed for a similar period. Section 3 Clause C is the exception to the previous provisions, where abortion is only allowed if the pregnancy would risk or harm the mother's life. This provision is related to the common moral principle that can be found in the theory of natural law, known as the principle of double effect. This principle renders abortion procedures morally illegal, since the action of abortion by its very nature is evil. However, other possible medical actions could be permitted to save the mother's life, even if it could possibly result in the unintended death of the unborn child. Likewise, in Islamic jurisprudence, exceptions are made if the mother's life is in danger. This is based on the Quranic provision in Surah Al-Baqarah verse 233, where a mother should not be made to suffer because of her child. This can be further supported upon legal maxim in Islamic law, where certainty should not be overridden by doubt. The probable existence of the baby should not undermine the mother's stable life. Although both are technically alive, the mother's existence took priority since her life is clearly established, whereas the fetus within her is less certain. Lastly, Section 4 allows abortion for a pregnant woman who was a victim, provided that the pregnancy is not more than 18 weeks and it was authorized by the woman herself and the registered medical practitioner. So this provision was included to protect the mother's right and quality of life. Judith Jarvis Thompson, one of the philosophers under analytical jurisprudence, stated that in the case of rape, abortion does not violate the right of the fetus when the fetus is not viable and hence it is not considered as an unjust killing. Accordingly, under Islamic jurisprudence, during the first 40 days after conception, majority of Islamic scholars permitted abortion when it was consented, especially for clear legitimate reasons such as rape or the physical and mental inability. The Shafi'i school allows abortion to be performed up to 120 days. In addition, many contemporary juristic assemblies holds the position by the Hanbali school of thought, permitting abortion up to 40 days and only up until 120 days, which is not more than 18 weeks of pregnancy.
I drafted on exploiting women for purposes of prostitution. Section 5 describes of someone who encourages or facilitates another person to commit prostitution. This provision is included in the Act is to protect the woman who is being encouraged to commit prostitution. This action of encouraging someone to commit prostitution is considered as immoral under the natural law. Immanuel Kant, believing that prostitution constitutes a grave violation of a person's moral duty. Thus, it can be said that the act of encouraging someone to commit prostitution is indeed immoral. This section 6 describes the act of someone that kidnaps a woman with the intent of subjecting her to a life of prostitution. This provision shows that there is an exploitation of women and can be considered as a sex trafficking. This provision is included to eliminate this kind of acts where it deprives the woman's freedom. According to the feminist jurisprudent Catherine McKinnon, a feminist is stated that prostitution as constituting a dome of violence against women. Sheila Jeffries explaining that prostitution constitutes the ultimate in the reduction of women to sexual objects, which can be bought and sold to a sexual slavery that lies at the root of marriage and prostitution and forms the foundation of women's oppression. Thus, they seek to have all prostitution classified as a human rights violation. The act of exploitation, prostitution, and sexual slavery are the acts that rejected under the Islamic jurisprudence. In verse 33 of Surah An-Nur told us about the hard struggle of women slaves to escape themselves from exploitation and sexual slavery that had been done by their master based on their power relations. Surah An-Nur verse 33 stated that, "And force not your mates to prostitution if they desire chastity, in order that you may make a gain in the perishable goods of this worldly life. But if anyone compels them to prostitution, then after such compulsion, Allah is oft forgiving, most merciful to those women wishes He will forgive them because they have been forced to do this evil action unwillingly." This provision describes someone that acts on the prostitution service as selling, purchasing, hiring, advertising, acting as an intermediary in the movement of prostitute, and receiving financial by selling the prostitution service. This provision is included to eliminate these prostitution services. Islam has accepted and established the dignity of women as the honored and respected human being. Women have been prohibited to be utilized and consumed as a material or products by sale. There is a hadith that proves Islamic jurisprudence reject the act of purchase, sell, hire, and receive financial from the prostitution of the woman. Jabir reported, Abdul ibn Ubay will say to his servant girl, "Go earn us something from the prostitution." It was in this connection that Allah Almighty revealed, "Do not compel your slave girls to prostitution if they desire chastity, seeking thereby the interest of worldly life. If someone compels them, Allah is forgiving and merciful to them after their compulsion." Section 8 of this act describes the person who distributes products that related to prostitution and indecent acts. This provision is included to eliminate the distribution of indecent act or pornography. Under feminism jurisprudence, the most radical feminists write about sexual issues, including pornography. The most controversial theory of radical feminism is the argument that pornography violates the civil rights of women. Catherine McKinnon argues forcefully that pornography is a type of gender violence. By presenting women as objects, it dehumanizes and silences them. Moreover, pornography invades its victims' civil rights, defining it as the graphically sexually explicit subjugation of women.
So now I proceed with the section 10, 11, and 12 of Women Rights Act 2022. This section is about sexual harassment. Generally, sexual harassment is defined as an unwelcome sexual behavior that is offensive, humiliating, or intimidating. It could be in a form of written, verbal, or physical, and could happen physically or virtually. In natural law, Aquinas, one of the scholars, opined that law is defined as an ordinance of reason for the common good made by him who has the care of the community promulgated. According to Aquinas, the human's role as the recipient of the natural law, as natural law contains principles of practical rationality, those principles by which human action is to be judged as reasonable or unreasonable. He also emphasized that fundamental idea of natural law is a participation in the internal law. in which all creation is ordered to follow the rational plan accordingly, the natural law as the way of human being as a part of the eternal law. According to the idea of good is to be done and evil avoided, sexual harassment is against the natural law which violates one's right to life in the sense of its dignity and reputation has been violated by the other. Human being is created with the capability of good reasoning within its nature. The reason helps human to reveal natural law that are in line with nature and creation of humans such as self-preservation, marriage and family and desire to know God. Therefore, this theory of natural law has enlightened that humans could use their reasoning to refrain themselves from committing offense such as sexual harassment and the other offenses. In this theory also stated that natural law is unchangeable and applicable to all human beings, even man-made law may vary in time and circumstances. Human law must be obeyed as long as it does not contradict with the natural law. Furthermore, the view of Islamic jurisprudence. In the contemporary Arabic term, sexual violence was known as at-taharruj al-jinsi. Etymologically, at-taharruj al-jinsi means committing to conflict al-tahyid, perpetuating the destroy al-ifsad, and creating the damage, hate, and battle al-ijra, while terminologically can be defined as every sexual statement and action that were used to attack and disturb other people. The Quran prohibited sexual harassment both physically and non-physically. The Quran defines sexual harassment both physically and non-physically as arafat and fakhisha. According to the Quranic interpreters al-mufassirin, term arafat mean al-ifhashi lil mar'a fil al-kalam, which means as nasty saying or statement to women that tend to sexuality. While fakhisha is almost similar with arafat, means vicious action and nasty statement that attack and degrade the humanity and woman's human dignity. The nasty statements and vicious actions that tend to sexuality, such as giving comments on woman's body, such as sexy, war, and other body shaming actions that degrades woman's body sovereignty. In a hadith, Prophet Muhammad SAW said, if someone's head among you is stabbed by the iron needle, it is better for you rather than groping a woman who is not his own wife. In another hadith, the Prophet ﷺ said, if you've weltered with the pig covered in mud and dirt, it's better for you rather than you lay on your shoulder to another woman's shoulder who is not your wife. Both of the hadiths affirm that sexual violence is strongly prohibited in Islam because it degrades the human dignity, whether it is the dignity of the perpetrator and furthermore the dignity of the victim.
Section 13, 14, 16, and 17 are related to Western jurisprudence. All of these sections are relating to each other in defining the wrong act of stalking and the punishments for the acts. In the Western jurisprudence, the theory that describing these sections is natural law theory. Section 13 defines about the person who commit the acts of stalking others and make the victim live a fearful life. The person committing the acts, as stated under Section 13, has acted immorally because he has prevented the victim from living her good life. In natural law, every person in this world must live a happy life without fear of others. So because of that, Section 13 is related to the natural law theory. Meanwhile, Section 14, 16, and 17 stated about the punishment for the person committing the wrongful acts that had been defined under Section 13 of the Act. This is in relation with the natural law theory, which prohibits any person from living in immoral life and to give a safeguard to the victims. Section 20, 21, 22, and 23 are related to Islamic jurisprudence. All of these sections define domestic violence in Islamic jurisprudence. The application of usul al-fiqh is applicable for these sections in which the subject matter of usul al-fiqh, which are the sources from Quran and Sunnah, may be applicable. Islam's position on domestic violence is drawn from the Quran, prophetic practice that is Sunnah, and historical and contemporary legal verdicts that is fatwas. The Quran and prophetic practice clearly illustrate the relationship between spouses. The Quran says the relationship is based on the tranquility, unconditional love, tenderness, protection, encouragement, peace, kindness, comfort, justice, and mercy. Section 20 defines the acts that may constitute domestic violence, which is related to the Quran that forbids abusive behavior towards a woman because it contradicts the objectives of the Islamic jurisprudence, which is the preservation of life and reason, and the Quranic injunctions of rightness and kind treatment. Sections 21, 22, and 23 have been created based on the compensation that has been allowed in Islam, which is ta'zir.
My name is AMALIA AIMI and my matrix number 056807. Today I'm going to present my provisions that I created pursuant to the assignment of Jurisprudence LLB 31303. My provisions that I created in Women's Rights Act, which is in section 24, 25, and 26. For section 24, it relates to Western jurisprudence based on feminist jurisprudence. It says about how the elimination of discrimination can be done in working environment. Section 24 subsection A stated of it can eliminate the inequality in terms of employment opportunities. Section 24 subsection B when it comes to field of employment. Section 24 subsection C for the benefit and job ranking, which we often see as inequality happens in this era. Section 24 subsection D for an equal remuneration, including bonus and salaries, and Section 24 subsection E more to social security. I take these provisions to be put into the Act is because Janet Ripken, one of the Western jurisprudence theorists, said of the law is powerful both as a symbol and vehicle of male authority. For example, women were denied access to certain professional occupations. As a result, women are left without remedy against domination by their husband. The School of Feminist Legal Thought challenges the assumptions of male authority and it seeks to erase gender-based distinction recognized in the law, thus enabling women to compete equally in the marketplace. One of the feminists is Harriet Taylor. For Section 25 also relates to Western jurisprudence and emphasizes more on married women, where subsection A stated of the paid maternity leave and subsection B for a special protection. The reason of me taking this provision is because Toni Morrison, which is feminist jurisprudence theorist, claimed that under the banner of liberal feminism, women won most of their legislative and judicial histories, including the suffrage, which is right to vote, equal pay, benefits, access to employment and education, the right to serve on juries, and the limited right to choose to terminate pregnancy. Catherine Bartlett shows that in analyzing the practice of law by courts and lawyers, there has three feminist legal methods are used. The first one is asking the women question, the second one, feminist practical reasoning, and third one, consciousness raising. For the method of asking the women question, it seeks to uncover the gender implication of rules and practices which might appear to be neutral or objective. For the method of feminist practical reasoning, it challenges the legitimacy of the norms of those who claim to speak through rules for community. And the last method, which is consciousness raising, it is an interactive and collaborative process which articulating experiences and making meaning of them. Hence, the provision I stated above relates to this claim. Section 26 provides of the offense, which is whoever are proven to have a discrimination against a woman shall be punished with imprisonment for a term which may extend to 2 years, or shall also be fined not exceeding 5,000 ringgit or both.
That's all from us. Thank you.